Hello and welcome to this podcast on the English and Welsh legal system with Ryan Murphy. Today, I wanted to talk to you about an aspect of the funding of legal services. And the aspect I wanted to talk to you about was the provision of legal aid. Now, legal aid is a fundamentally important aspect of the legal system of England and Wales, and also one that's gone through radical, rapid, and highly controversial reform in recent years. And as you listen to this podcast, I'd like you to reflect upon the place of legal aid, the current place of legal aid in the legal system, and what you think the proper place for legal aid in the legal system might be. So let's start off by looking at some context. So legal aid was established in England and Wales in the late 1940s, following the war, 1949. You have the introduction of legal aid. And the function of legal aid is to provide, through the legal system and through legal professionals and others, support to those who would otherwise be unable to access legal support. So this is for the poorest, the weakest, the most vulnerable in society to be able to get access to justice. And access to justice is one of those phrases that's bandied about a lot, is pushed around a lot. But access to justice is a fundamentally important aspect of any legal system. There is no point in having a legal system and legal rules if everyone in society can't have fair and equal access to that legal system. And so have a little think about some of the philosophical reasons why we might wish to provide legal aid. What is the underpinning rationale for having a system whereby the government pays for the legal representation, legal advice, support at court for individual citizens? Why is it that we have a system that provides that safety net for those who would otherwise be unable to access legal support? Think about who is it that legal aid serves. And here's where you can get narratives and counter-narratives. You can get perspectives and counter-perspectives. You can get different lenses through which you might wish to look at and think about legal aid. So if you were speaking to the government and the government is keen to reduce the costs of legal aid, you might ask them the question, well, who is it that legal aid serves? And the government might reply that it serves the poorest and weakest in society. Fair enough. But it also serves the interest of legal professionals who can get rich off the public purse by providing legal aid work. Or the government might come up with an even more toxic narrative, which might be that legal aid is used to reward and support those who have been part of or are accused of criminal behaviour. If you were to ask that same question to the legal profession, who does legal aid serve, then you might get a very, very different answer. And what I would like you to think about is, what is the narrative, what is the counter-narrative, and why do those narratives exist? And fundamentally, whose interest is legal aid there to support? And there is a very, very good book published fairly recently by The Secret Barrister, which unpicks lots of these questions around lots of issues in the legal system, but in particular talks quite persuasively and emotively about legal aid and the changes to legal aid. And I would encourage you, if you can get access to that book, to have a read of it. So, what does legal aid tell us about a legal system? What is it that we can garner, gather, and understand about a legal system from the way in which it treats those who are subject to legal aid? These are all open questions. I don't expect to provide answers to you, but just to get you to start thinking critically and deeply about these issues. And the reason I picked legal aid to speak with you about, of the very, very many topics I could have recorded a short podcast about, is because legal aid is, although it's been around since the 40s, has been subject to fairly radical recent and controversial reform. And it's something where there is an ongoing program of reform to legal aid, and you might wish to look at current thinking around the implications of recent reforms on legal aid. So, as I say, the recent history is of reform, and those reforms have, at least on the face of it, a few aims. But at their core, at their heart, there is a bid to cut costs. And so, particularly through the 80s and through the 90s, the legal aid budget crept up and up and up to the extent which it cost the government £2 billion in 2009 to administer legal aid in the justice system. And at a time of constrained resource, at a time where other government departments are being cut, legal aid came very much within the focus and target of successive governments. It's not just a party political issue. This has crossed governments, whether that's the coalition government of the Conservatives and the Liberal Democrats in the 2010s, whether it's the Labour governments from 1997, or whether it's the earlier Conservative governments. Legal aid has been a target of governments because it's seen as a way of saving significant sums of money from people who can seem to be afford it, so saving money at the expense of lawyers, or saving money at the expense of things that are not going to harm you in the election, like treating criminals, alleged criminals, accused criminals more harshly. So traditionally, this was a demand-led system. So it notionally had a budget, but anyone who qualified for legal aid was able to apply and get legal aid. And in that way, the government was signing a blank check, a potentially blank check, when it dealt with legal aid budget. One of the things I'd like you to have a little think about is, if you do reduce legal aid, if you do reduce the amount of money going to legal aid, does that really save you money? Does that really save the government the money that it says that it saves? So if you half legal aid from 2009 from 2 billion down to 1 billion, have you saved 1 billion pounds? There's an argument that says, yes, you have. There is also an argument that says those costs are just transferred elsewhere, either to the NHS or to social care or to social services, or, for example, other costs in the administration of justice. And so if you reduce legal aid from those who can't afford it and they still wish to litigate, you have the problem of litigants in person. So you have the problem of people going to court unrepresented, and that takes away court time. So the judge is left in a position where they have to support more actively a party who has no legal representation. So legal representatives know the law, they know the processes, and they know the courts, and therefore matters can be dealt with more speedily than if you have an unrepresented client who doesn't understand necessarily the law, doesn't understand legal processes, and doesn't understand, for example, the rules on procedure. And so we have to ask ourselves really hard questions about whether you make a headline saving, is that an actual saving, or those costs just dispersed elsewhere? The reform to legal aid has had an impact on the charitable work of many organisations, including Citizens Advice, who had to receive some additional funding from the government because they had legal aid contracts in the past that they can no longer get. And it has had a fundamental impact on the work undertaken by many firms of solicitors and on many barristers, and particularly the aspects around fixed fees. So rather than lawyers being able to claim for time actually spent, they can have fixed fees. Those fixed fees do not rise particularly in proportion to the complexity of the case. And so you have many barristers who, there are claims that they essentially do a day's work in court and get £43 or something like that in a fixed fee. And this actually led to protests with barristers essentially going on strike in protest against changes to legal aid. So this is a deeply controversial set of reforms that have happened to legal aid and that were proposed to happen to legal aid that forced a profession that is not known for refusing to do work to refuse to do work. So there have been numerous reports, the Carter report, the McGee report. There have been lots of suggestions for change, but some of the things that caught the imagination of the government of the time and subsequent governments came from the Carter report. So rather than everybody being able to undertake legal aid work, now there is a consolidation, and there are contracts to be won for legal aid work. If you don't have a contract for legal aid work, you can't do legal aid work, therefore you can't get recompense from the state for the work that you've done, legal work that you've done. And the idea was to consolidate those who are offering legal aid work and thereby increase efficiencies, have bulk work done rather than individual work. A move from pay by the hour, so the traditional understanding of how a solicitor or barrister might be paid, to fixed fees and a form of managed price competition with some certain quality safeguards. But this has been very deeply damaging to those who undertake legal aid work. There was a perception in the press, and indeed the government launched a list of those who had claimed most through legal aid, and there were some barristers who had made £1 million from legal aid in a given year. But actually, the move to fixed fees has damaged the junior end of the market. So those who used to rely on legal aid in order to make a living as a barrister are now struggling, and many now see crime as a particularly challenging area for a new barrister because of the lack of well-paid work. That the other thing that the Carter report suggested was a greater targeting of legal aid, civil legal aid in particular, to the most vulnerable in society. And so large swathes of areas of law that used to be covered by legal aid, for which you could get legal aid to support your legal proceedings. According to the Carter report, there was a suggestion, a recommendation that they moved away from that inclusionary model to more of an exclusionary model. And eventually this all culminated in the Legal Aid Sentencing and Punishment of Offenders Act of 2012, LASPO. And this is an infamous act in what it did to change legal aid. Legal aid used to be administered by a non-governmental department, the Legal Services Commission. It was brought more in-house into an executive agency under fairly tight control from the Ministry of Justice, a government department. And it made significant reforms to the system. And we'll talk about some of those reforms as we go through. So let's turn our attention then to how legal aid works in broad terms in civil matters. So the Legal Services Commission, as I say, was replaced by the Legal Aid Agency, which is an executive agency of government which has a budget set by and through the Ministry of Justice. That the sorts of levels of service, as LASPO would put it, that you can get vary. So you can get different forms of support for your civil claims in civil matters. You could get legal advice, so things like advice on your options, advice on the law, etc., and support from a legal advisor in terms of writing letters, etc. You can get legal representation, where someone can represent you in proceedings by going to court or tribunal on your behalf. There are other forms of support that you can get, like support in things like mediation if you're in a family law dispute, etc. But the main areas that you can get support is in legal advice and legal representation. That the examples of areas that are now included you can find in Schedule 1 of LASPO. So if you wanted to go to LASPO 2012, find Schedule 1, you will see the areas that are included. Now this is a change around. So it used to be that everything was included unless it was specifically mentioned as excluded. Now, the only things you can get legal aid for are the things that are specifically allowable. And this includes certain forms of debt cases, very, very limited advice and representation you can get in debt cases, largely where your property might be at risk. That certain family cases, but not very many family cases, mainly those involving coercive behaviour or allegations of domestic violence, etc. So the vast majority of family cases now, the government has decided are not eligible for legal aid. Why? Because in part, the government says that most family matters do not require recourse to court, to litigation, and therefore you shouldn't actually need to have legal advice and support of the state in that. Care proceedings for children, you can gain legal aid in those circumstances. If there are issues surrounding domestic abuse, then you might be able to get legal aid funding. But these are just examples, but the list is a fairly limited list. There's been a narrowing of the areas in which you might be able to claim civil legal aid. There are some areas that are excluded. So up until fairly recently, you could get help and assistance in medical negligence claims. That's now been ruled out, other than in very, very limited circumstances involving children with significant brain injuries. But most medical negligence claims now are ineligible for legal aid. That the vast majority of personal injury claims are ineligible for legal aid. And that might be slightly curious because of the volume involved, but in part, PI claims are expensive to run and the risks are fairly high in terms of costs if you lose. And so the government took a policy decision in effect to say we're not going to be supporting PI claims through legal aid. That most matters of trusts law, administration of estates, things like writing wills and all the rest of it, you can't get legal aid support for. Employment law matters, you can't get legal aid to support your employment matters. One of the rationales or thinking behind this, I guess, is the fact that there are other institutions and associations that might help you with employment law matters. So things like trade unions, etc., that there's more likely to be legal insurance for this sort of legal dispute. If you have home insurance, for example, it might cover you for employment-related matters, but employment law excluded. That divorce law generally, provided there's no allegation of domestic abuse, excluded from legal aid. Now these are school admissions claims, etc., etc. So what you can see is that a very large swathe of potential civil law claims are now excluded, or have over time been excluded from the ambit of the framework for legal aid support. In order to claim legal aid, it's not just that your case falls within one of those areas, you actually also have to be eligible. Now, this eligibility is largely, if you think about it, related to the purpose of legal aid, which is to support and help the most vulnerable in society who would otherwise be unable to gain access to legal advice, legal support, legal assistance. And so there's a financial eligibility. Your earnings and your capital need to be below a certain level before you can claim. There's no point rehearsing what those levels are. They are in most cases below the average for, or thereabouts at the average working wage, but there is a very, very complicated way in which all of this is worked out. And if you are so interested, you can go out and you treat it as a research exercise to go away and find out the precise details. But largely speaking, it does vary by area, and it also varies by the level of support, whether you need legal representation or whether you just need legal advice and support. But essentially, it's worked out on your income and your capital, on the income and capital of your partner, and partner is defined in the relevant legislation fairly broadly. And then, not only do you need to be eligible from a financial perspective, there is also, for most types of claim, a merits test. Is there merit in the case going ahead? And in order to assess whether it satisfies the merits test, the law adopts a prospects of success approach, and therefore the funding will only flow, legal aid will only flow to those who have a relatively good chance of succeeding in court. That's problematic for a whole number of reasons that I won't go into now, but perhaps you could just have a think about why it might be problematic if you only support those cases that have a moderate or better chance of success. And then technically overlaid over that, again, a little bit too much detail to go into now, it must be a public interest test. Is it in the public interest to support this applicant in this sort of proceedings on on these grounds? If we then turn away from from civil legal aid, we'll touch very briefly on criminal legal aid in criminal matters. So again, you need to have eligibility, you need to have financial eligibility. Those in receipt of certain social security payments, certain forms of benefit, automatically qualify for legal aid. That's because by definition their income will be below a certain threshold. There will still be a test as to their capital and their partner's capital and income, but generally speaking, those on receiving certain social security payments, certain social welfare benefits, will be financially eligible for legal aid. There are all sorts of tests that are done, applied, allowances that are applied to assessing someone's financial eligibility, and that includes the presence of dependents, maintenance payments made to former children of former relationships, all those sorts of things. And then applied over that is an upper adjusted. You adjust for the dependents, adjust for other deductible amounts, and you look at someone's adjusted income. And if your income is above that adjusted income threshold, then you might be required to make a contribution or indeed pay in full for your legal advice, support, assistance, representation. Before the financial eligibility test, there is an interest of justice test. Is it in the interest of justice to support this sort of claim? And that might look at prospects of success, the consequences of someone not being awarded a legal aid support. So that might be if there's a likelihood of being found guilty leading to a custodial sentence, those sorts of things. As I say, and linked to the interest of justice test, is that the vast majority of criminal matters, particularly those or those that lead to the potential for imprisonment, are eligible for funding for legal aid. As I say, if you want to learn more about legal aid, this is just supposed to be a broad sketch of the principles so that you can make an assessment as to whether the law is currently effective as it applies to support for those who need assistance in criminal and civil matters. But if you really want to look at this deeper, I would strongly recommend you read The Secret Barrister's fairly recent book. It is fantastically written. It is inspiring and alarming in its treatment of the criminal justice system, and particular criticism is given to legal aid. And so, is legal aid fit for purpose? So reflecting right back to that initial slide, that initial opening, what is legal aid there for? It's there to support the most vulnerable in society who would otherwise be unable to access justice. And often when a government reforms an area, as it has done here in legal aid, it is trying to strike a balance, whether that balance is between the rights of many against the rights of few, whether it's against cost and individual freedom. The government is often exercising essentially a balancing test between competing interests. What I would like you to do is to think very, very deeply and carefully about the information that I've given you. Go away, do some more reading, and consider whether the recent reforms and the recent proposed reforms to legal aid strike that right balance between access to justice, which is a fundamental principle of the rule of law. So the very legitimacy of the legal system rests upon its adherence to the rule of law. Does and do the current reforms strike the right balance between that quest for justice and the important mission of government to spend money, taxpayers' money, appropriately and responsibly? How do those two policy aims, how do those two really important principles collide, and have the recent reforms performed a correct, adequate and appropriate balance? And for now, that's all I wanted to talk about. It was a very brief overview of legal aid, essentially trying to get you to think rather than trying to give you answers. I hope that you found it useful and that you will be back for yet more podcasts on aspects of the English and Welsh legal system. Thank you very much indeed. Goodbye.